Welcome to the show. Now, Justice Binta Nyako of the Federal High Court in Abuja has struck out 8 of the 15 terrorism and felony charges preferred by the federal government of Nigeria against the detained leader of the indigenous people of Biafra, Nnamdi Kanu. Justice Nyako freed Nnamdi Kanu on the 8 counts while ruling on a preliminary objection filed by the IPOB leader. Now, the judge said, having read counts, there is no offense against the defendant in counts 6, 7, 8, 9, 10, 11, 12, and 14. The judge says counts 1, 2, 3, 4, 5, 8, and 15 shows some allegations which the defendant has to answer. And now this is coming on a day when journalists were actually barred from getting into the courtroom because of new practice directions by the Chief Judge of the Federal High Court. Now this has raised tension among media practitioners, including civil society organizations, with others saying that this is an offense against the constitutional provisions for freedom of speech and freedom of press. Well, I will be having Ifeanyi Ejiofor, who's one of the counsels to Nnamdi Kanu, right here to discuss this issue with me, and I'm glad to have him here on the show. So good to have you again, Barrister Ejiofor. In the midst of all of this, we have seen the judge trim down the count from 15 to 7 now being preferred against Nnamdi Kanu. These are the ones that the judge feels that have some merit to be heard. What do you make of this latest decision? It must be some sort of joy to you and your supporters and of course your client.
Thank you, Mr. Sumner, for having me in your program. First of all, let me correct an impression that the judge said the remaining count, outstanding 7-count charge has merit. He said they have an allegation that needs to be explained, actually. We are making progress. I will just summarize in that form because what's the confusion about the ruling of today is that we have 14-count charge that has to do with a broadcast made from an unknown place, not specified under the law, which they classified as an act done in furtherance of an act of terrorism. So also to be corrected is the fact that it's not standing offense for act of terrorism. So the judge found merit in objection on count 7, 9, 11, 12, 13, and the 15. That is the 8-count charge, and dismissed them. However, from count 1 to 14, they are interrelated. They can be separated because they has to do with, they are predicated upon a broadcast made from an unknown place, not defined, and also received in a place not also defined.
Isn't it within the territory of Nigeria?
No, it wasn't defined. It wasn't stated in the charge whether it was received in Abuja or in Anambra State or in Enugu. So these are fundamental issues we believe we are going to address in. I have to address in court of appeal. Then 2, the facts of count 15 borders on importation of transmitter. The court also found that that charge was predicated on a non-existent law, because the court said it has gone through the criminal procedure, criminal code act. He didn't find any place in the act where the offense of force censure was also provided for. But based on the powers and relying on extant laws, the court amended it. So if I will ask in the circumstance, this has to do with importation of an item, assuming without considering to the fact that such constitutional offense. And court also, it's very clear, the count is very clear. Item imported, kept in Obulisuzo in a local government. What will come to you quickly, which was part of the arguments we canvassed before the Federal High Court, is whether the Federal High Court in Abuja has jurisdiction to entertain matters on alleged act, constitutional offense that was committed in Obulisuzo. The answer is no. It's in negative. So we want to commend God for the effrontery, for the hard work in coming up with the ruling of today. But we believe we are going to address the remaining count, because that has also dealt with the entire allegations leveled against our client, and it also paved way for us to take his bail application, which was done today.
Yeah, before we actually go ahead, looking at these counts one by one, when last did you meet your client, and what's his state at the moment? I mean, he was in court. How has it been like with him all through this while?
However, it has been, we usually visit him Mondays and Thursdays in line with the court's guideline and order. So apart from few occasions, and many occasions they denied us access to him, and in each of those occasions we try to let the public understand what is going on around him. So we are a team of lawyers visited him yesterday, before today. Yesterday was Thursday. So we had received some complaint, which I believe I made public yesterday, about the fact that his clothing he's not allowed to change his clothing.
Despite the earlier court order.
So, of course, in the character of the SSS, of course, they are very chronic in the flouting of court orders. So they've not allowed us access to him to change his clothes. So, despite court prevailing substantive orders. Then two, the court also made a pronouncement. Of course, it was addressed today by NESILC, Right Professor Zokome Sen, about the pronouncement by the court, the direction given by the court, and should allow us access to his private medical personnel, doctor, who will conduct independent also investigation to have a second opinion about his state of health. And that order hasn't been complied with. So these are part of issues raised today by our late counsel, SAN Michael Zokome, which court director we should also forward to him, to the courts, so they can be given administrative attention. So these are all evidence of the flouting of orders of court by the SSS. So, and also, don't forget that our client hasn't been convicted of offenses being alleged he was involving. He has been subjected to solitary confinement.
Yeah, because these are terrorism-related charges preferred against him by the federal government.
Let me correct this impression, because many a times you hear the prosecution talk about treasonable felony, you hear him talk about terrorism offense. I've been able to state ab initio that he's not being charged with terrorism offenses.
Yeah, but terrorism-related offenses, that's what
there's a different thing between somebody being charged with act of murder. It was explained today by NESILC, and the person who's being charged by manslaughter. So, because the difference between the two offenses lies in the punishment ascribed to them. So they're not interrelated. Offense of terrorism is clear, and offense of acts done in furtherance of act of terrorism. They are all different offenses. So, and that impression needs to be corrected. So, and however, the law presumed him innocent of these offenses as it stands today. So until found guilty. So he hasn't been found guilty, and by virtue of which he's entitled to the full rights that contained under Chapter 4 of the Constitution. Right? So by subjecting him to this act of solitary confinement by SSS, in clear violation of Section 2 of Anti-Torture Act, is an infringement on his right.
Yeah, but if these were just mere charges, the court would have granted him bail.
No, the bail application has been taken today, and we are of the firm view that the court will find merit in application, because there is nothing before the court. The prosecution has not been able to establish, by virtue of what they filed in response to our application, reason why he will not be granted bail. If you talk about him, the issue of the allegation of jumping bail has been laid to rest by order of Federal High Court in Umaya, because the court has found that his home was actually invaded on the 10th and 14th of September 2017 in desperate attempt to eliminate him. Assuming, without considering to the fact that they succeeded, the agent of the state that invaded his premises succeeded on that day in killing him. We'll be talking about the charge today. The answer is no. That's simple.
Yeah, but the reality is that it's difficult for the courts to actually trust Nnamdi Kanu with the bill.
I'm coming. The point is clear. The Nnamdi Kanu expressed his willingness to be in court on October 17, 2017 to face his trial. I have to say this publicly. We have taken him on pre-trial conference before then. He was ready to come. He even announced that he wants 1 million followers to follow him, to accompany him to the court on that day. He wasn't afraid of anything, he was ready. And why can't you wait, assuming without considering to the fact that he committed any offense during the period in question? The simple thing we have been for you to wait and allow him to come to court. There's no law that says we will not arrest him in court You arrest him after the trial. So, okay, you have
well, after having jumped bail and gone out of the country.
I'm talking about 2017. He didn't jump bail.
Okay, before.
So after High Court in Umuahia delivered a judgment and found federal government liable of gross violation of Nnamdi Kanu's right by blood invasion of his home on 14th of September and 10th of September 2017, and court directed. Up till now, they've not complied with that order.
Okay.
That they should issue public apology to Nnamdi Kanu and also explore other options to resolve this matter. The court found the invasion of his premises unlawful, unconstitutional, and a gross violation of his right. So the issue of jumping bail has been laid to rest.
Okay.
By virtue of that.
I'm being told that I don't have enough time left.
Sorry about that.
Let's talk about the issue of the practice directions, which stopped journalists from getting into the courtroom. Do you think in one way or the other this may affect your client, especially if journalists are not there or members of the public to see how the trial is going?
The fact is clear that we can never allow that practice direction to stand. We are not oblivious of the fact that it was actually put in place because of our case. We are very familiar with that.
It's not only him that has terrorism-related
we are
charges.
Why? Okay, now, a witch cried in the night and a child died in the morning. Are you with me? They've been there talking about practice direction. Why did they issue yesterday? Why did they come out yesterday? This is a simple question that is begging for answer.
So you think Nnamdi Kanu is the target here?
However, we have looked at the provisions of the practice direction issued yesterday, and we have the firm belief, the Leonard Silk, and made it public today, that some portions of these provisions are in clear violation of the provision of the Constitution. So right to fair hearing, the right to have the public be part of the proceedings. You can never beat a child and expect not to cry. You can never share the press from being part of the proceedings, because Nnamdi Kanu has been tried in the public by the federal government. Nnamdi Kanu has been condemned in the public by the federal government. Nnamdi Kanu has been convicted by the public by the federal government. So the trial must be witnessed by the press. So we are intending to challenge. The SARC has made it clear to the world that we are going to challenge the unconstitutional provisions in that part direction issued yesterday, and it will happen soon. So because we know what they are trying to do, and we can't allow them to have their way.
Okay, very interesting indeed. And we just hope you will help us, even as journalists, to be able to have access.
You must be part of the proceedings.
Because everyone in the country is interested in knowing what happens at that trial.
It can't be done in secret. You must be part of it. Because when they were granting interview about what and what not Nnamdi Kanu did, the judges were there when the learned AGF condemned him and convicted him in the public. And in court, we are doing our best. And today, we've seen the result. All right. And we're making further progress. Well, and we move.
We can't wish you well. We must thank you so much. Ifeanyi Ejiofor is the counsel to Nnamdi Kanu, and he's been on this trial all through. And we just hope that the right authorities do the best, what is acceptable by law in this circumstance.
Thank you so much.
Thank you so much for being with us. You're still watching the Arise interview. Plenty more still ahead, including reviewing the issues of this practice directions as how it affects journalists. Stay with us.